On Christmas Eve 2025, as the city of Washington, D.C. lay quiet under a blanket of snow, a sense of anticipation hung in the air. American firearms law sits in suspense, with both sides of the debate anxiously awaiting the next move from the nation's highest court. The Supreme Court recently declined to hear a direct challenge to the National Firearms Act of 1934, or NFA, a law that has shaped gun regulation for generations. This wasn't a ruling on the law's merits, but a decision to wait, leaving the fate of the NFA unresolved for now. For gun rights advocates, it was a setback. Many had hoped for a landmark decision that could reshape federal gun laws. For gun control supporters, it was a brief reprieve, a moment to regroup as legal battles continue across the country. The NFA, nearly a century old, remains in place, regulating certain firearms through taxation and registration, and serving as a cornerstone of federal gun policy. The court's silence has fueled speculation. Is it avoiding the issue, or simply waiting for a more suitable case to address the complex questions at stake? Any Supreme Court ruling on the NFA would have sweeping consequences for gun ownership in America, potentially affecting millions of gun owners and altering the legal landscape overnight. Recent court decisions have left a patchwork of standards nationwide, with different states interpreting gun laws in their own ways. The justices seem to be proceeding with caution, aware that any decision could set a powerful precedent for years to come. By stepping aside, the court is watching how lower courts handle ongoing legal battles, gathering insight before making a decisive move that could reshape the nation's approach to gun regulation. The future of the NFA and the Second Amendment remains uncertain, with both sides preparing for the next chapter in this ongoing legal saga. For now, the legal landscape is unchanged, but the sense of anticipation continues to build. The debate is more intense than ever, and the nation waits to see what the Supreme Court will do next. To understand today's legal fight over firearms, we need to look back at the origins and evolution of the National Firearms Act itself, a law that has shaped American gun policy for generations. Passed in 1934, the NFA was not an outright ban, but a tax law designed to curb the violence of the era. It specifically targeted weapons associated with notorious gangsters, machine guns, short-barreled rifles and shotguns, silencers and certain explosives, by making them harder and more expensive to own. The law imposed heavy taxes and strict registration requirements, making these items both costly and difficult to obtain. The paperwork alone was enough to deter many would-be owners. To legally own an NFA item, applicants had to submit detailed paperwork, provide fingerprints, undergo a thorough background check, and pay a $200 tax, an enormous sum in 1934, equivalent to several $1,000s today. Even now, the process remains slow and burdensome, with wait times often stretching for months or even longer. Many find the bureaucracy daunting and the cost prohibitive. For nearly a century, the NFA has stood as the backbone of federal gun regulation, weathering repeated legal challenges and adapting to changing times. Critics argue the law unfairly burdens law-abiding citizens, creates a government registry, and could pave the way for future confiscation of firearms. They see it as an overreach that infringes on constitutional rights. Supporters, on the other hand, view the NFA as a necessary safeguard, one that helps keep especially dangerous weapons out of the wrong hands and protects public safety. The law's impact is still felt today, shaping not only who can own what, but also the cost and complexity of legal gun ownership in America. The debate over the NFA's fairness and effectiveness continues to fuel heated legal and political battles, with passionate voices on both sides. Today, the NFA's future hangs in the balance as new legal challenges and shifting public attitudes put its legacy to the test. Its legacy remains central to the ongoing fight over gun rights in America, shaping the conversation for generations to come. In August 2025, the NRA and other gun rights groups launched a bold lawsuit to overturn the NFA. They argue the law infringes on the Second Amendment by making it nearly impossible for ordinary citizens to own certain firearms. The lawsuit claims the NFA's taxes and bureaucracy function as a de facto ban, violating the Supreme Court's Heller decision. Registration requirements, they say, threaten privacy and could lead to confiscation. The groups also challenge the logic behind the law, arguing that items like short-barreled rifles and suppressors aren't uniquely dangerous. Their goal, to dismantle the NFA and expand the definition of protected arms under the Second Amendment. This legal battle is about more than paperwork. It's about the very scope of gun rights in America. The Supreme Court's refusal to hear the NFA challenge wasn't unexpected. Legal experts believe the justices are waiting for a cleaner case, one with clear facts and a focused constitutional question. The court often steps in when lower courts disagree, creating a circuit split. By letting more NFA cases play out, the justices can see which legal arguments rise to the top. Some think the court wants a narrower challenge, like one focused solely on suppressors. This incremental approach lets the court test the waters before making sweeping changes. The current justices are cautious, aware of the political stakes. They may be waiting for a sympathetic plaintiff and a compelling story. When the right case arrives, the court's decision could reshape gun law for generations. While federal courts wrestle with the NFA, states are taking a new approach to gun control. Several have passed laws banning communication or advertising about firearms to anyone under 18. These broad statutes cover everything from magazines and websites to safety courses. Supporters say they prevent the marketing of gun culture to youth. Opponents argue they violate the First Amendment, chilling speech about hunting, sport shooting, and safety. Organizations now face tough choices: risk legal action or restrict access to their materials. Even educational content is at risk, from youth shooting teams to hunter safety manuals. Gun rights groups see these laws as an attack on both speech and gun culture itself. The fight over these speech codes is now a top priority for Second Amendment advocates. In response to these state speech laws, the NRA has restricted access to some online content, requiring age verification for firearm-related materials. The organization insists this is a temporary, reluctant measure to avoid lawsuits while court challenges proceed. The new laws directly interfere with the NRA's mission of promoting firearms safety and education, especially for youth. Many members are frustrated, seeing this as forced self-censorship. The NRA's strategy is twofold: comply with the law to avoid penalties, but fight aggressively in court. Alongside other groups, the NRA has filed lawsuits arguing these laws unconstitutionally restrict truthful discussion of legal products. The outcome of these cases could determine how and if gun culture is passed to the next generation. For the NRA, this legal fight is now central to its mission. The stakes are high. The right to speak about guns is now as contested as the right to own them. These new state speech laws have created a fresh legal battleground, one that's drawing national attention and raising fundamental questions about the boundaries of our constitutional rights. For the first time, the First and Second Amendments are being linked in courtrooms across the country, as legal challenges force judges to consider how these two foundational rights interact. Now, the fight isn't just about owning guns or the right to bear arms, but also about the freedom to talk about them, to share information, and to advocate for or against gun ownership. Legal scholars believe the Supreme Court may be waiting for a case that combines both rights, one that could clarify how far government can go in regulating speech about firearms. Such a case would offer the justices a rare opportunity to set a powerful precedent that could impact both gun policy and free speech for generations. The NRA's lawsuit against these speech restrictions is a prime example of this new legal strategy, arguing that these laws don't just regulate conduct, but silence a specific viewpoint and chill public debate. They claim the restrictions go beyond safety concerns and restrict content based on its message, which is a red flag for constitutional law. Courts are typically suspicious of such content-based speech bans, often viewing them as threats to open discourse. By framing the issue as one of free speech, not just gun rights groups hope to attract broader support, including civil liberties advocates and those who may not own guns themselves, even from justices and citizens who are more moderate on gun rights, but have a strong record of defending free speech and the First Amendment. A Supreme Court ruling striking down these laws would strengthen both the right to bear arms and the right to speak about them without fear of government reprisal. It would also set a precedent for future cases, ensuring that debates about firearms remain open and accessible to all Americans. This could be the strategic first step before the court tackles the NFA directly, laying the groundwork for even bigger changes in gun law. The intersection of speech and gun rights may ultimately shape the next chapter in American firearms law, redefining the limits of both rights for years to come. As 2025 ends, the future of gun law is uncertain but evolving. The Supreme Court's pause on the NFA isn't the end, just a waiting game. lower courts will decide the fate of the NFA and the new state speech laws, with appeals likely to return to the Supreme Court. A win for gun rights groups on speech could protect gun culture and embolden future Second Amendment challenges. The justices seem to be waiting for the perfect case, one with a clear constitutional question and a sympathetic plaintiff. For now, the NFA stands, and states continue to experiment with new controls, but the groundwork is being laid for a major Supreme Court showdown, one that could redefine both gun ownership and the freedom to discuss it. The next big ruling may not just be about the Second Amendment, but about the fundamental link between the right to bear arms and the right to share knowledge about them.